is People ex rel. Welch v. Maginley-Liddie. Counsel.
For the Appellant, Legal Aid Society by Danielle Welch. May it please the Court. The Appellate Division erred in two ways.
Counsel, do you wish to save any time for rebuttal?
Oh, I'm so sorry. Yes, I would like to save 2 minutes for rebuttal, please.
Sure.
Thank you. The Appellate Division erred in two ways. First, by finding that out on bail was a qualifying status for the purposes of CPL 510-10-4T, and second, by finding that the requirements of that statute were otherwise met, particularly the requirement of demonstrating reasonable cause. A case on which bail has been set and posted is not eligible as the basis for a 4T application, simply because the legislature did not authorize that.
But the legislature put in non-monetary to qualify conditions in 4T, toward the latter part of that. How do you reconcile that with your position?
Well, Your Honor, the key question in interpreting the phrase is which omission matters, because neither non-monetary nor bail appears in the statute that is being interpreted today. In interpreting 510-10-4T, the prosecution and the appellate division focused on the omission of the word non-monetary, but the crucial omission is the omission of the word bail. When the legislature wishes for bail to be included, they do so explicitly.
Is there a difference between a monetary condition and bail? Is there something that would be a monetary condition to release that's not bail?
I am not aware of any monetary conditions other than bail.
So wouldn't the absence of non-monetary then imply that bail might be part of the consideration when you're talking about conditions?
If we were viewing this one line in a complete vacuum, that is a plausible reading. However, we have to construe statutes in the context of how they appear as a whole. When the legislature wants bail to be an included status, they say so explicitly. There are at least 7 sections throughout the collected bail statutes.
But they could do it different ways, right? They don't always have to do it the same way, and this is kind of a unique statute, right? So here, it's release. These are the various ways you were released, non-monetary, monetary conditions, released on your own reconnaissance. So why isn't that a logical reading of the statute, particularly, I think, as Judge Singas said, where they use non-monetary, where they want to use non-monetary in this statute?
Because there are at least 20 other examples of conditions appearing without the modifier non-monetary in
I've looked
context.
at those, and they seem to all be an implied condition. So in the beginning, they mention non-monetary, and then later in the statute, or it says nothing. It says no modifier. But the modifier is implied from the context there. But the opposite seems to be true here, where the lack of a modifier in the initial and the use of it later implies the opposite.
If the legislature wanted for bail to be included, as Your Honor suggested, there are certainly different ways to do it, and there are many different ways that the legislature did do that, including in language that pre-existed at the time that this section was drafted. What they have never done is unambiguously rolled that into the word conditions. They have done it in various ways. They have said when a person is at liberty as a result of a securing order, which unambiguously encompasses any securing order. They have included bail explicitly. What there is not an example of is conditions clearly, unambiguously including out on bail. And there is not support when you look at the statute as a whole to read it this way, particularly given that that reading would render the majority of the phrase that it is found in superfluous.
So do you think there's no difference between non-monetary conditions and conditions?
I think that when the legislature is using the word conditions, and specifically in this section under conditions, they are referring to non-monetary conditions.
So in your view, it's the same thing. It has to be, right? Non-monetary conditions and conditions. And can you point us to anywhere that the legislature meant that? Otherwise, why would they include the words non-monetary conditions if it's the same thing?
I agree that it certainly would have been more clear if they had included non-monetary. However, because of how it was drafted, the courts are required to either read in non-monetary or to read in bail. And it is clear throughout the statute that when bail is intended, it is done explicitly. As to your question about examples, there are, as I mentioned, at least 20, and most of those appear in contexts that can only be understood to refer to non-monetary conditions. For example, in 510.3a and 510.3b, conditions appears without the modifier non-monetary 8 separate times, and those provisions define.
Well, how about the fact that it's not defined, statutory definition, but what's to prevent use of its ordinary meaning to include bail?
Certainly. What prevents that is how this word is used throughout the statute. And although the appellate division cited to the provision that defines cash bail, the language there actually says that the person is released upon the condition. And although I recognize that that sounds incredibly nuanced, upon the condition is clearly using the word.
So if you post a monetary bail,
Yes.
doesn't matter what you do thereafter, you're not captured by the statute. Is that your view?
Yes, that is my
And
view.
so so you don't have conditions because you posted monetary. But if you have a non-monetary, then you're covered.
Right, because this gets at the two separate definitions of conditions, which I believe the appellate division improperly conflated when they cited to the definition of cash bail.
Can I ask you, a practical question? So Mr. Ortiz is out on bail in the Bronx.
Yes,
He then goes and allegedly uses a credit card and is charged with things in Queens, if I have that right. Why couldn't the people go back to the court in the Bronx and say, pull his bail or increase it?
they can do that. And I believe that that is what the legislature was actually intending to set up when they excluded bail from 510.10.14.
But let's say, the statute clearly applies to, by its terms, it applies to underlying crimes that are both bail eligible and not bail eligible, right? It does.
Yes.
It says it does. So why wouldn't that also be true in the case where in the Bronx, let's say, a person has a bail eligible offense, but the judge exercises the judge's discretion and says, I'm not going to set bail, I'm going to release you on conditions. Now they're arrested in Queens on a qualifying charge under T. Why couldn't the same thing be said? Why don't you just go back to the judge in the Bronx and say it's a bail qualifying offense? Why don't you set bail now?
Certainly.
You could do that, right?
You could set bail if cash bail had not been set, even though it was a
So,
qualifying.
but in your view of the statute, you could also go in the other district, let's say Queens, and fall under T because the person is in bail.
Yes.
So doesn't that somewhat undercut that the theory of this is you can just go to the first court and ask for bail or bail to be revoked, when you could kind of do the same thing as long as it's a qualifying offense, right?
What the legislature did by omitting bail from 4T is they actually set up a thoughtful system in which the discretion to impose additional cash bail goes to the judge, who is in a better position to judge whether or not the rearrest impacts the risk of flight. In this example, Mr. Ortiz's Bronx case was undeniably more serious than the one in Queens. And the judge who was presiding over that matter has been on this case, is aware of
And
those
that
facts.
It's all
And-
relevant to the Bronx charge.
Yes.
But this applies to the new charge. So you're giving discretion to the judge facing this defendant in a new charge to make that assessment with respect to what is now a bail-eligible crime, which wouldn't otherwise be, except for T. It's a different calculation, right? It's, are you going to appear for this charge, not are you going to appear in the Bronx, right?
It is, but it's also a securing order that doesn't exist in a vacuum, because the judge is, by virtue of the wording of this exception, considering both cases. Now, when the legislature was enacting 4T, the legislature.
But when you have the new charge, the person gets separately arraigned, and that judge who the accused is brought before has to determine a status of release, correct?
Yes.
And we would agree that if the charge standing alone is not bailable, the judge can't set bail, correct?
Yes.
However, where is it noted in the statute that that judge on that new charge, because of the other offense, what prevents that judge from now exercising the ability to set bail pursuant to the statute?
What would prevent them from exercising discretion is if the individual had already posted cash bail on another matter. If you look at the purpose of this amendment and go back to the legislative history.
So, but for the cash component, that's what you're saying prevents the new judge from utilizing the statute?
Very simply, what the legislature has set up is a thoughtful system in which if additional cash bail is going to be imposed, then that decision must be made by the court that has more
But
information.
why wouldn't an argument be had? I have a new charge. I otherwise don't have the ability to set bail because it's not a bailable offense. But now I have information. This person has a charge pending. There is a statute that says I get to consider that in conjunction with this case that is my case and the circumstances under which it is alleged. Why is that offensive to what the legislature was doing? And in other words, they're just simply providing two different avenues. One, you could go back to the original judge, get bail revoked under that jurisdiction. But two, the new judge now has the ability to set bail because of the fact of the statute allows them to consider the first offense.
Because the purpose was to close a loophole that under the original reforms, a person could be arrested an unlimited number of times on non-qualifying offenses and never be eligible for bail. However, when the legislature was doing these amendments, they were not seeking to radically expand the number of people who were incarcerated pre-trial. And so what they landed on was a system that balances not imposing additional cash bail on the basis of a charge that is not qualifying. And let's be clear, it is not qualifying because these are the sorts of crimes that rarely result in jail time, even if convicted.
So it seems to me that there are textual arguments on both sides here, right? So why is it that we should read the text as you say? I think each side has some challenges with their interpretation. Is there something about the legislative history or the practical workings of the scheme? What, in your view, weighs more heavily in your favor?
Both of those things weigh in my favor. The legislative history is clear that they were trying to close that specific loophole. Senator Palumbo, during the debates, specifically raised the question of somebody who is never eligible for cash bail, no matter how, I believe she phrased it as, if they pick up a non-qualifying offense every single day of the year, they cannot have bail set. And so that reading is consistent with excluding bail because the person already has bail and there are systems in place to modify it that provide greater due process and put the judge in the better position to assess the impact of this less serious non-qualifying offense on the existing flight risk.
But that loophole is not entirely closed, right? Because under 53060, you can only modify the bail if it's a certain type of bail, like if you're a certain type of crime, if you're intimidating a witness. There will still be crimes that will not be eligible for modification. So your theory that they did it just to close this loophole has a hole in it, right? Because it doesn't cover everything.
Respectfully, no. Only 53060 sub 2 has those specific restrictions. The judge can go under 53060 sub 1 to specifically assess whether there is good cause based on this rearrest. And just, if I may briefly address reasonable cause, because I think it is connected. When the judge is evaluating a modification, they are considering everything. They know how many times a person has come to court. They know the details of what's going on in that first case. A judge sitting in arraignments has almost no information about that case. And that is especially true here, where they had literally not even a complaint. And so putting the burden on the judge in arraignments who has nothing outside of the complaint to assess this flight risk and evaluate what this actually means is not the best placement of discretion for evaluating that person's risk of flight.
Thank you.
Thank you.
Good morning, Your Honors. William Brannigan for the Office of District Attorney Katz. May it please the Court. Your Honors, the arraignment judge properly set bail on the defendant in this case under Section 510-4T because the defendant had been released on a condition, that condition being
But it does,
bail.
counsel, it does seem odd that the legislature knows that bail is different, uses that phrase for it to be absolutely absent from this section.
Your Honor, bail is absent from this section, but so is non-monetary. So conditions is a broad word, and bail is used in conjunction with conditions, including in the section, I think it's 510-40, that lists conditions.
But I think you're reading conditions out of the statute entirely. That is, at least as I understood the argument you started to make, if we struck the word released on conditions, keep releasing and struck on conditions, your argument would still be the same. That is, if a defendant is released, then the subsequent court can set bail.
Well, I agree, Your Honor. If you had no conditions that just said released, then yes.
It'd be the same as your interpretation.
Yes.
So you're reading on conditions out of the statute. It's superfluous.
Your Honor,
Well, the statute would mean the same thing whether we had those words or didn't.
well, Your Honor, I'd put it this way. I can't think right now of if it's recognizance conditions or recognizance conditions or something else. I don't know
Well,
what
it couldn't
else.
be escape, presumably. We wouldn't count that as released.
No, Your Honor. So
Is there some other way to get out?
I agree. If it just said released, it would essentially be the same. You could say just release. But, Your Honor, conditions here is used alone. It should be given its plain meaning, and I'd note that non-monetary conditions actually has a meaning. It's defined in the statute, whereas conditions is not defined in the statute. So where we have only conditions, we should start out by giving conditions its plain meaning.
Why isn't it based on the structure of the bail reform? That when the legislature means bail, it says bail, and conditions usually means these non-monetary conditions.
First, Your Honor, I'd say this was a reform to the reform, and here they chose to use this word. The word has a plain meaning, which goes to a requirement on the release, and here bail is both a requirement in the sense that they have to post bail and that they forfeit that money should they violate the
I'm
court
sorry,
order.
that's good, I want to ask you too. So the condition is both the posting of the bail as well as the potential to forfeit the funds?
Your Honor, I'd say that in two different parts of the statute. So in 510-40, we can look at the posting of the bail as a condition for release, and in a separate section, I think it's 510-1010. It talks about the forfeiture as a condition to the bail. So I'd say yes, Your Honor, posting the bail and then maintaining those conditions with the unique idea that you'll lose your money. Should you violate those conditions?
Is that a condition or a consequence?
Well, I guess the losing the money is a consequence, Your Honor. So the bail itself is a condition, losing
So
the
the
money.
condition is you'll be at liberty if you can find this amount of money that you would forfeit, that would be the consequence if you don't show up.
Well, I would say yes, posting the bail, I'd say the release is on the condition that you post bail. And that bail, but it is a condition because the bail, you do risk forfeiture beforehand, and so that is essentially part of a bail condition, yes.
Let
What
me
is
ask you
your-
this about another part of T, which I will also ask on rebuttal of your friend on the other side. Later in T, it says, provided, however, that the prosecutor must show reasonable cause, I'm sorry, not about reasonable cause, I'm sorry, for the purposes of this paragraph, that's T, any of the underlying crimes need not be a qualifying offense as defined in this subdivision. Does that in any way inform the fact that bail is not expressly referred to earlier in the subparagraph?
Well, I'd say that I'd say that's an expansive term. It does not have to be it's saying it does not have to be one of those qualifying offenses. So it could be a qualifying or not qualifying offense to begin with.
But let me put it another way. What is the point of that? Why include that?
I think the language is included to be more expansive, to include crimes and not to exclude crimes. And expansive to the sense, in the sense that if somebody is a repeat offender, there isn't a particular, there's not a particular loophole where they cannot have bail set. So I think that language is meant to be more expansive and not more restrictive.
What is your response to your adversary's argument about the legislative history here?
Your Honor, as far as the original legislation, it was certainly meant to reduce the people who could be incarcerated on bail or held for other reason before trial.
And I think she argues that your reading would not serve that end, or
Well,
would undermine it.
Right, Your Honor, but that was the purpose of the reform to the reform, where they were responding to too many people being released and then rearrested. So that was the reason for the addition of T. So this is a reform to those original reforms, which is meant to tighten the statute, meant to expand the number, the category of people who are eligible for bail under the statute.
Well, was it meant to deal specifically with the case that Senator Palumbo, the type of case that he referred to, that is, a whole string of non-bail eligible offenses where there's no basis to put no ability to put somebody in, no matter how long they continue that? Is that what it was targeted at?
Yes, Your Honor, but it's I would say first, yes, that's the common situation, or a number of say petty larcenies in a row, which clearly wouldn't qualify, but would now qualify under this statute. But here, just looking at the facts of this case, you have a defendant who committed a violent crime. He posted bail and was released. During that time, he committed a new offense.
Right, but that goes right back to the first question I asked, which is, to deal with that, you wouldn't actually need this amendment, right? You could have dealt with that under pre-existing law. It's just a question about which court would have dealt with it.
Well, I think there's two questions, Your Honor. The first question is the court, and it's not just a matter of a particular courtroom. That can be a different county, as here we have Queens to the Bronx, and that becomes an impossibility for the new court to set that bail. But second,
wait, let me stop you there. I'm not sure I understood. For the new court,
the new court cannot
that is the Queens court couldn't. Right.
Right.
So that's my question about, isn't this just a question of which court, not whether you could hold this defendant based on the conduct?
Well, I accept that, yes, it is which court, but it is important which court, because it's important that the court who has the new case in front of it is able to impose the bail.
Why?
Well, for two reasons. First, the reasons I just suggested, which is the difficulty of going back to the original court to have bail set. But the second, and probably...
I'm sorry, what was the difficulty
What's the
there?
difficulty?
The difficulty of bringing the defendant back to the original
You mean
court.
logistical difficulty?
Well, that could be mainly a logistical difficulty, but the new offense. But just going to the second reason, Your Honor, the new offense will not have a separate hold. So the defendant could have any number of prior offenses. Once those offenses become resolved, the new offense would immediately the bail would not be there. There would be no hold on the new case. So it is a matter of keeping a hold on the new case where you have a reoffender. So it's important in this case, once, say, the original case pleaded out, to still have hold on a person who, during his time out, committed a new offense.
So that he spends no time out. Is that what you mean?
Well,
Because
so
he
that
could issue a warrant for his arrest.
Right, Your Honor, but the existence, but again, the existence of the reasonable cause for the new offense on the original offense shows and provides reasonable cause to the court that this person cannot be trusted during his release. And that gives reason for the court to set bail on the new offense and not simply rely on the original offense.
So are you saying there are two separate avenues for addressing the defendant's bail status? The original court on the attempted murder charge has the ability to have him brought in upon an application of a bail revocation, but the new charge the judge assigned there has a separate ability to assess bail status because of the first charge.
That's correct, Your Honor.
Otherwise, if the first charge didn't exist, it would not be a bailable offense.
It would not be bailable, and if the first case is resolved, there would be no hold on him in the new offense, despite the fact that that defendant had reoffended.
Well, if
So
the
they're
first
separate.
Sorry, go ahead.
So charge number one, he has bail that he posted. And until or unless he goes back to that court, that bail stays in place. The new judge sets bail on the second charge because the court can take into consideration the first. But, and if that judge, the second judge sets bail, he has two holds. But depending on how they're resolved, he doesn't necessarily have to be held on both cases at one time, correct?
That's correct, Your Honor, because one of the cases could resolve, and then he would not have a hold.
Yeah, but the case we're talking about resolving is, in this case, the murder case, and presumably that could be resolved in one of two ways. It could be resolved by a plea, likely, right, or I suppose a trial, but that's something that would result in a judgment of conviction on a fairly serious set of charges, which then the person is incarcerated, right?
Right.
Or it could be resolved by an acquittal or a dismissal of the charges because the people decide this is not worth prosecuting or he's not guilty or whatever. In that second circumstance, then what you'd be doing if you had a hold in the second case is holding somebody on something the legislature has determined is not bail eligible.
No, Your Honor, in the second case, should the case be dismissed, the defendant can always go back to court and make an application for his release. He can go to court and say, I should be released because my case was dismissed. But if he, for instance, pleaded guilty, received probation on whatever the original case was,
on a murder
or a conditional
charge?
Discharge, the defendant could still say, I should be released, and the people could say, no, he has a conviction, and there's nothing here in the facts of this case that permit his release.
Why would the fact of a conviction affect his flight risk?
Your Honor, my argument is that the fact, so to start with, the fact that there was reasonable cause that he had reoffended during his time out is what provides the discretion under the statute for the new hold. The conviction, I mean, in theory at least, it could demonstrate.
Yeah, but of course,
an
the original court, right, in this
Right.
case, the Bronx court, had that discretion with or without the statute.
That's correct, Your
Right.
Honor.
So all we're talking about is whether the second court might have discretion in what we've now sort of played out as a circumstance where the first charge is dismissed.
That's
Which is
right.
the serious charge. So that all he's really been, I mean, he's innocent until proven guilty, so all that's left is a charge that's not bail eligible. So we'd have to find some, I guess, since we seem maybe to think that the statute has some ambiguity in it, and the legislative history might have some import, we have to find something in the legislative history to suggest that's a desired result. Is there something?
First, Your Honor, I just say regardless of whether you could have that situation regardless of whether he was bailed in the first offense. I'd say also that it's not just a matter that the first offense might be a bail eligible offense. The reading here would be that if he was released on particular non-monetary conditions, like seeing a social worker, whatever the different conditions are, that would have made him eligible. So you'd have the same situation where that original case can be dismissed, and then they would have to review the bail under that
But I think
condition.
unless I'm misunderstanding you, if if the first one is a bail-eligible crime, right, first conviction, first indictment, right, as we have
Yes.
here, and he's not bailed, instead he's given non-monetary conditions, then I think even your adversary here would say that subsection T applies.
Correct, Your Honor.
Okay.
And that in itself is inconsistent.
Why is that?
It's inconsistent because all the arguments being made, meaning the defendant can still go back, or the people rather, can still go back and apply for a new bail condition, there'd still be potential bail on that original case. So if you were to consider it that way, if you have a case where the bail could be potentially placed but isn't, he would still qualify under T, but for the same offense, because the court considered it this is a more serious case or a flight risk, that the court sets bail. Now he could not have bail set on him in the new case, even though the same thing essentially transpired, which is that there's reasonable cause that he committed a new offense under this statute.
So you're saying the legislature could have written the statute better?
Well,
If it had the objective that counsel wants?
Your Honor, yes. If that was the objective, yes. Otherwise, you create these inconsistencies where people in essentially the same place who have committed essentially the same crimes would not be eligible under the new statute where they would be or they would not be had bail been set. So you create those inconsistencies with that reading. And I think if you stay with the plain reading of the statute, if you stay with the plain reading of the word condition and the way that it's normally used in the statute, bail is a condition and the defendant can have bail set in this case.
Thank you.
Thank you, Your Honors.
I'd first like to address the idea that it is a problem that bail would not be eligible if the first case were resolved. That in the example provided by Mr. Brannigan, if bail were set on case A and not on case B because of this reading, that there would be no way to detain him on case B if case A were resolved. That is absolutely not an inconsistency that is codified in this statute. In CPL 51020 sub 3, the court is required to issue a new securing order if a case is resolved in a way that it would not be eligible for 4T at that time. And so the idea that the legislature did not intend for someone to be released on the first case if the first case went away is plainly incorrect.
Counsel, just to go back to this last point that your adversary was making here.
Yes.
If the purpose of this statute is to provide a way to set bail when that wasn't possible before, meaning you couldn't go to, we'll use the Bronx example again, the Bronx and have, bail was not able to be set there, why would they put the language that Judge Rivera cited to, the underlying crime need not be a qualifying offense, which we seem to all agree on. So and I think this was the point your adversary was trying to get at, where your underlying crime in the Bronx is a qualifying offense, you can always go back there and deal with bail then. Why wouldn't this statute only apply where the underlying crime is a non-qualifying offense?
Because because the legislature decided to provide more discretion to judges than simply allowing to set bail on multiple non-qualifying offenses. The problem they wanted to avoid was a non-qualifying offense being the basis for a second order of cash bail. And so the inconsistency that it would still be possible for a person to have two securing orders, as was raised, is not actually an inconsistency because the non-qualifying offense would not be the basis for the second order. The problem is
But let's say they did go back and they did both. There's conditions set in the Bronx. Now Queens comes up. They go in Queens. There's conditions under your interpretation. They can set bail in Queens. Can they also go back to the Bronx and say, there was a violation of your conditions here in the Bronx? Why don't you set bail here? Couldn't the judge in the Bronx do that too, and wouldn't you have the same result?
They absolutely could, but it is not the same result, because the case that is imposing the second securing order imposing cash bail is a qualifying offense, and that decision is being made by a judge who is
So
familiar.
it's just the order? You still
No.
have two bail orders, right? It's just the sequence of how you do it?
I apologize, I didn't mean to interrupt, but
Oh,
no,
no,
it's
no, I
not the
think I
order that
interrupted you.
matters. It is the fact that the judge sitting in the first case has more information. What happens in arraignments
But in
happens,
my hypothetical, they go to the Queens judge first, and they get a securing order, they get bail set, then they go back to the Bronx, and they say, you had released this person on conditions, now we want bail set, because they were arrested in Queens. Wouldn't you have two securing orders, and wouldn't you have the same sequence you're worried about?
you would have two securing orders, but it is not the same problem. Because the problem that exists with reading 4T to apply when bail has been set is specifically that an otherwise non-qualifying offense, something that the legislature has found should not be the basis for cash bail except for in particular circumstances, should not be the basis for
But
you
isn't that
spending
the
time
same
in
in
jail.
my hypothetical? Why is that different in my hypothetical?
It's different in your hypothetical because then the second decision is being made both on a more serious matter and with more information than is generally
Bail
going.
is still being set on a non-qualifying offense in Queens, even though there was a qualifying offense in the Bronx. And it's being set first in Queens by a judge that is not as familiar with the Bronx case as the Bronx judge.
Yes. Respectfully, I think it would be very odd in practice for somebody who was released on a qualifying offense to have bail set then on a non-qualifying offense because the analysis by the first court was that they did not pose a risk of flight.
That was before the second arrest.
Yes, but the purpose of bail is not to ensure that people do not commit new offenses. And I think the heart of many.
Theory being the risk of flight is greater, right, when you have another crime.
Yes, but a new non-qualifying offense does not generally increase risk of flight.
But isn't that the whole purpose of this statute? I mean, harm on harm, you're increasing risk of flight by harm on harm. Otherwise, why would we have this? So you have to find that, right, to set bail.
The purpose of the statute is that so individuals who are arrested on numerous non-qualifying offenses have a
Does it say
mechanism.
numerous, or could it be one?
Well, the example that was given in the Senate debates when this was being
Right, but the
drafted was
statute
numerous.
itself, it can be one, right?
That is correct.
It can be one additional offense.
Certainly, if the required findings are made and the risk of flight justifies that. At the heart of all of the arguments to the contrary is the idea that somebody is eligible for bail because they cannot be, I believe the words used were trusted during release. Bail is not a preventative mechanism. It is only about return to court. And returning someone to court after a new arrest is not actually a difficult thing. They are at liberty. They can go to court. They have been released after posting bail, which is already ensuring their return to court. We know this because the bail hasn't been modified after it's been posted. And so it isn't as if somebody is being released with nothing holding them at all. They have already posted significant, often, resources. And the reality is that most
And
people
I
are.
think if they went back and got bail posted in an original count in the Bronx that was bail eligible but was set on conditions, then you wouldn't have, then you could go into the Queens Court and say you can't post bail anymore because now the statute is satisfied, because you have bail posted in the Bronx now. In my hypothetical, no bail in the Bronx. Now you get arrested, you get bail in Queens, you go back to the Bronx, you get bail in the Bronx. Why couldn't the Queens person go in, the defendant in Queens go in and say, you know, now there's no reason for this bail anymore because I have bail in the Bronx?
Well, they can argue that.
Statute doesn't apply anymore.
Well, 510-10-4T is always an arraignment-only statute. But what happens in your hypothetical, if I am understanding it correctly, and please cut me off if I'm
I
not.
may not be articulating in any way that's understandable. So.
But if I am understanding correctly, in your hypothetical, the reason that it is different and the reason this is a thoughtfully designed system is that in your hypothetical, the person is going back to the judge who has more information. There has been more opportunity for both sides to collect information.
Wait, can I interrupt you on that point, please? Because in the 22 amendment, I'm looking at the words of Senator Bailey. I don't know if he's the one who introduced it, but he said, we want to make sure the statute was clearer and easier for judges to be able to interpret in determining their decisions when there is a matter before them. So it sounds that he's talking about the arraignment judges here, not about the judges who may have the most information in the Bronx. He's saying we need this because we need to make it simple for the judges when these cases are before them at arraignment, because we're talking about 510 at arraignment. So I don't think that what you're saying is actually what they meant, that they're looking to get it to the person with the most information, because he's clearly saying here, we need to make it simpler for the person who it's before at arraignment. Am I wrong about that?
I certainly would not say that, but this was not the only amendment in the 2022 arraignments. There were many things, most of which do clarify what is happening at arraignments. But what 4T does is it's simply providing a mechanism to set bail on non-qualifying offenses or qualifying offenses if somebody is released. But it was closing that loophole, and the most specific probative information in the entire legislative history on that point is the debate that I referred to previously, where the specific example given was closing that loophole. And the goal remained limiting pretrial detention. Nothing about the amendments changed that, and as Your Honor has just pointed out, the goal was clarifications. It was not a radical expansion of the pretrial population. And so
I guess my concern is that I don't see that it was clarification, or that the clarifying fact would be whether someone posted bail or whether there was an ROR. So two similarly situated people commit the same crime, and one of them in your reading of the statute, the one who posted bail, would be treated very differently than the one who was ROR'd. And I just don't see anything in the legislative structure that would support that.
Well,
I don't want to belabor it, but that's
well, the issue is, and this gets back to which omission matters, when the legislature wants bail included, they have always done so explicitly, and they have also consistently used conditions without the modifier of non-monetary throughout the statute in contexts that can only be understood to apply to non-monetary conditions.
So then I promised that I would ask about section T in this particular language when you got up on rebuttal. So why doesn't the language, any of the underlying crimes need not be qualifying offenses? Doesn't that suggest that this also applies to offenses that qualify for bail? Otherwise, why would you need that?
I am absolutely not arguing that it does not apply to qualifying offenses. The distinction is whether bail was actually set and posted.
I see.
And the issue here is ultimately that bail is not a condition. It is a contingency. And you see that in the syntax of how it is worded. It is upon the condition, not under conditions.
That's a slightly different argument, though. That's even if it's conditions, this doesn't fall as a condition, right?
Yes. Sorry.
Just
But it is, I believe a question that was asked earlier that I didn't have a chance to respond to was whether conditions is actually defined anywhere. And in the definition of non-monetary conditions itself, the word appears without the modifier of non-monetary 8 times. And more probatively, I think, in 51040 sub 5, which is discussing exclusively non-monetary conditions, there is a requirement that judges notify individuals of any conditions to which the principal is subject to serve as a guide for the principal's conduct.
But that,
And bail,
again, I think the first part of your sentence is that whole section refers to non-monetary conditions,
Yes.
right? So when you're just shorthanding conditions, it's an implied modifier. And I think that's the same with the other 3C section that you cited, which cites back to 3B, 510-3B, which uses it without the modifier, but it cites back to 3A, and 3A says non-monetary conditions. So there's always, it seems to me in those statutes, an implied modifier.
That's not true in every example.
So
There-
which is the one where it isn't? Because those
Sure.
two, that's how I read them.
Just 1 second, please. That is also true in 51045 sub 5, which describes what needs to be reported by pretrial services monitoring individuals released under non-monetary conditions. The reporting requirements are described as conditions.
But that's
in-
non-monetary conditions. That was the first part of your sentence. Those are non-monetary conditions, right?
Yes. Regardless, the statute is always clear when bail is intended to be considered. There is not a clear example to the contrary, and because the overall purpose of this statute was to reduce incarceration, and this reading achieves the effect of limiting how much money an indigent individual, and let's be clear, most people in criminal court are indigent and represented by public defenders, it limits the ability to set additional secondary cash bail on very limited arraignment information. And this example, or this case is the perfect example of why this is a problem, because the judge had no information whatsoever. It should not have been granted based purely on their failure to establish reasonable cause. But the fact of the matter is, if this had instead been handled by going to the Bronx and asking for an increase, both sides would have had a lot more time to get the relevant information, instead of asking to take somebody's liberty based on no information at all. And
Thank you, Counsel.
yes, thank you.